Now, in case you missed it, Thabo Bester and his partner Nandipha Magudumana will be back in court on the 20th of June. Meanwhile, the bail applications of 5 of their co-accused, all former G4S employees, is continuing today. Now, let's unpack today's court proceedings. I'm joined by legal analyst Melusi Xulu. Mr. Xulu, thank you very much for your time here on eNCA. Let's first discuss a point that was raised by Thabo Bester's new lawyers. I'm going to come to the point of the fact that he keeps changing lawyers, but let's come to what they said in court today. They said they were never told that he would be appearing virtually. It was never their agreement, and they're raising concern about getting instruction from him as their client. A very valid concern, right?
It's a valid concern. Firstly, the section that was used was Section 159A of the Criminal Procedure Act, where the accused matter can be postponed using an audio-visual link, which was what happened to him and Dr. Magudumana. So that was an arrangement, but maybe they did not communicate. But for consultation purposes, they can always arrange consultation where he's located. So I think that can be arranged that way. So that was what I thought about that. It as much as they wanted to arrange that he could come to court, but for security reasons, I must say that the state felt that it's better that the matter is done virtually than him coming to court. So I think that was the main thing, that it was as per law, as per Section 159A of the Criminal Procedure Act.
And that's an understandable application by the DCS. I think a lot of South Africans would agree, because we all saw what happened after the 3rd of May last year with Thabo Bester escaping from prison. But let's talk about whose fault is it then that he couldn't, that his lawyers couldn't, speak to him or get instruction from him and consult with him, because the first time he appeared in court, he changed lawyers. We found out through a statement that he would be changing legal representation. Today, we find out again that another lawyer is standing down and another lawyer is being appointed. So whose fault is it then logistically that these lawyers couldn't get the time or didn't know that he was going to appear virtually today?
Yeah. Look, when you get an instruction, like I'm not privy to how they communicated with the state, but when you get an instruction of someone who's in custody or is still in prison, you obviously try to make arrangements with either the police or the correctional services to come and meet him when he's in custody, so you can get enough time to consult him. So I think that arrangement should be done between the client and the attorney with the officials that I just mentioned. So I think there should have been a communication amongst themselves, the people that I've mentioned. Yes.
Tell me, I don't know what your thoughts are, and I'll describe to you. The two virtual appearances were quite different today. Thabo Bester was in a room at the Kgosimampuru prison in Pretoria with 3 DCS guards, right? While Dr. Nandipha Magudumana was in a library, no guards around her. Will this kind of treatment of the two, who both, by the way, escaped from law, and were arrested in Tanzania, will the treatment currently of the two, the difference in the treatment, speak to the case later on when it gets to the trial court?
I don't want to speculate as yet, but I did not observe what you're saying, but it's quite interesting. I suppose the person that they perceive to be more dangerous will be Thabo Bester, but I don't think it will play much of a role, because we still need to hear what evidence will be brought when it comes to court. So I don't want to speak much on that, but I can see that maybe they perceive him to be more dangerous than the doctor.
So what would be your solution then, Mr. Xulu, in terms of whether they appear virtually or not? Thabo Bester asked the magistrate whether his next court appearance on the 20th of next month would be virtual or not. Obviously, his lawyers don't want it to happen that way, because they want to be able to get instruction from their client, even from inside court. But looking at the fact that a trip from Kgosimampuru prison to the Bloemfontein Magistrates Court can be about 5 to 6 hours, so it's understandable, and it states money that is being used to transport him around. So where do we then find the balance? Should they use this time that they have to travel to Pretoria and get instruction from him?
Maybe that's what they can try to arrange, but obviously it will cost more for their client. The other thing that maybe one can ask is, obviously they need proper instructions, but as yet, is he applying for bail? what agency does he have with regards to?
Well, he can't apply for bail because he's serving a life sentence for serial rape and murder. Yeah. So he's definitely out in terms of bail application.
Yes, that's why I'm saying, what other reasons does he have to want to come to court? Because for now it's just postponement. I understand the attorneys' need that they want to have a proper consultation with him, which means if this Section 159A will be applying for some time, they will need to just go and see him and force him upon so that they can get proper instruction.
All right, I guess that would be the best way. And let's talk about, your thoughts around Zolile Sekeleni, the father to Nandipha Magudumana. He got bail. He was granted bail a few weeks ago of about 10,000 rand. And he has things that he needs to do to make sure that he actually keeps his bail, and that is obviously to follow his bail conditions. What do you think about that and the fact that there's this contention now about the murder charge that's been dropped against him, Nandipha Magudumana and Thabo Bester? It's a huge contention against the state, right, that they would drop this, or should we wait to see if they'll add it again?
As it stands, I think the attorney of the first accused did say that as it stands right now, we can't talk about a charge that is not currently counted as one of the charges. We're going to talk about assisting Thabo Bester to escape, fraud, bribery, and interfering with the cops. So for now, I don't think it's fair to say it's to speak before the court. Because initially when they were charged with murder, I had questions. I was like, who will testify that they are one of the murderers? So I think, just in short, as it stands, we're going to talk about the charges in front of the accused so that we don't speculate about something that will later added on.
Now, as a lawyer, Mr. Xulu, if you decide that you are going to reserve the right for your client to apply for bail, it means you're essentially saying at any point you'll let the court know that today we're ready or tomorrow we'll be ready, right? Could it be something that a lawyer does because they have evidence up their sleeve, something up their sleeve?
You can get many chances to apply for bail. You can apply for bail, it can be refused, you can appeal up until the highest courts in the country. But I suppose the first time they apply for bail, they want to make sure that they have everything they need. Because remember, especially if it's a Schedule 5 or 6 bail application, the onus is on the applicant, which is the accused, to prove on the balance of probabilities that you want to get bail. So I think they want to make sure they get their house in order, so they don't want to rush the process. I understand that they just need to get their house in order and not rush.
Well, we know the state is opposing bail, and it's going to be quite a lot of things that the magistrate will need to consider. She did flee when she knew that she was being looked for, and the state had to go arrest her in Tanzania. But at the same time, her lawyers might say this is her very first offense. But thank you so much for your time. Legal analyst Melusi Xulu speaking to us.